In the criminal justice system, the people are represented by two separate yet equally important groups: the police who investigate crime and the district attorneys who prosecute the offenders. These are their stories.
Alexander Hain, you are on trial for the grand theft auto, destruction of property, and endangerment of the public. How do you plead?
Hey, so Judge, I didn't steal that car. I didn't crash into no bank. I swears. Swears on my life.
My client pleads not guilty.
Mr. Gill, proceed with your prosecution.
Ladies and gentlemen of the jury, I present to you the first piece of evidence. Many credible witnesses and security cameras placed Mr. Haynes at the Poway High School staff parking lot before the incident and clearly stole Miss Meisel's car after school.
Jury members, Your Honor, the evidence is clearly circumstantial.
I object!
Did you hear that fallacy? That's right. Post hoc ergo propter hoc asserts that one event caused another because it preceded it.
Your Honor, if Principal Garrett, a respectable leader at Poway High School, believes that that man stole Miss Meisel's vehicle and proceeded to drive it into a bank, who are we to disagree with him?
Once again, Your Honor, no relevance to the case.
Do you guys hear another fallacy? That's right, it's a faulty appeal to authority. You can't logically believe something just because a trustworthy guy says so.
Your Honor, any student in any parking lot could have stolen Ms. Meisel's vehicle. Anyone in any school could have stolen.
Another one, boys and girls. This is the begging of the question fallacy. You can't have any unspecific claim that's also questionable.
Object! He's begging the question, Your Honor. I call the perp to the witness stand.
Would you put your right hand on the Bible? Raise your left hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
You know it!
You have to say I do.
I do. So, Mr. Haynes, where were you on the day of December 19, 2014?
I don't know. Going home. I definitely didn't steal Annika's Ford Focus, and I definitely didn't crash into no bank. God.
Wait, we have another fallacy. This is not only a faulty alibi, but also a faulty anecdote. You can't imply that your story is proof enough.
Mr. Haynes, we never said the car model. So how did you know that? You must have committed the crime.
Here we go. Another fallacy. That was a loaded question, boys and girls. You can't ask a question that presumes guilt.
Mr. Haynes, we have a credible witness that placed you at this scene of the crime. Miss Roby claims that you had a vendetta against Miss Meisel and the bank, so it all makes sense now. You committed this crime.
Oh! Another fallacy. This lawyer thinks he can use special pleading to prove that he is right. Nah, you can't invent ways to cling into old beliefs.
Your Honor, may I cross-examine my witness? Mr. Hain, why would you do such a thing?
Man, you know I didn't do it. Come on, I told you. I swear. We go back, man.
Your Honor, jury members, this young troubled boy is not a criminal. He's just tired from a long day of school. He just wanted to walk home, finish his APEL homework, and get a full night's sleep. How could he have done such a crime to his favorite student teacher?
That was good, but that's another logical fallacy. You should appeal to logic, not emotion. Come on, Mr. Lawyer.
Miss Lawyer, as a defense attorney, may I remind you of your dark past? Correct me if I'm wrong, but you were once convicted of arson yourself. You yourself you were once a criminal.
Hey now, was that a fallacy I heard? You can't just use tu quo qui. That just shows you as a hypocrite. Boosh!
That's irrelevant, Your Honor.
Defense, prosecutor, prepare your closing statements.
In conclusion, I would like all of you to consider Mr. Hain was at the scene of the crime and therefore committed the crime.
Well, in closing, he technically did not commit the crime because he has A's in all of his classes. And did I mention he's in AP classes?
Wow, those closing statements were full of fallacies.
Mr. Prosecutor with a false cause.
How could you just assume such a thing without evidence?
And Mr. Defense, how could you use ambiguity?
On a technicality? How could you? Fuck!
Jury members, have you decided on a verdict?
Retrial?